I am Polymopicus, and this is Polymopicus Legal. Legal concepts explained for non-lawyers, by a non-lawyer for educational commentary, and is not legal advice. Few words in law are used more confidently, and understood less accurately than this one. Hearsay. People invoke it whenever they dislike a statement, whenever they hear secondhand information, whenever they want evidence excluded. But hearsay is not shorthand for gossip. It is a technical rule about how truth is proven in court. Let's separate the myth from the doctrine.
Few legal terms are more famous than hearsay. It appears constantly in movies. It is used in everyday arguments. It is often shouted as if it ends the discussion. Hearsay. But in real courtrooms, hearsay is not a magic word. It is a specific evidentiary concept with detailed rules, exceptions, and limitations. Courts do not just care what was said. They care how the statement is being used, who made it, and whether it can be tested for reliability. Understanding hearsay is essential to understanding how evidence works. In general terms, hearsay is an out-of-court statement offered to prove the truth of what the statement asserts. That definition contains several important parts. Out-of-court statement. The statement was made somewhere other than the current testimony in court. It could have been said in person, in a text message, in an email, in a letter, in a recorded call, or in a social media post. A statement can be spoken, written, or sometimes intended conduct offered to prove the truth. This is the most important part. If the statement is being used to prove that what it says is true, hearsay concerns arise. Example: a witness says, "John told me the light was red." If offered to prove the light was red, that may be hearsay, because the real source of the claim is John, who is not currently testifying and cannot be cross-examined through that second-hand repetition alone. The hearsay rule exists because second-hand statements can be unreliable. The court wants to evaluate perception. Did the speaker observe accurately? Memory. Did they remember correctly? Narration. Did they describe it accurately? And sincerity? Were they truthful? When the original speaker is absent, testing those issues becomes harder. Cross-examination is one of the primary tools for testing reliability. If the true source of the information is not present, that safeguard may be missing. The hearsay rule is therefore about reliability and fairness. This is where many people get confused. A statement made outside court is not automatically hearsay. It depends on why it is being offered. If the statement is offered for some purpose other than proving truth, it may not be hearsay at all. Examples include effect on the listener. The statement is used to show what someone heard and how they reacted. Example: he told me there was a fire, so I ran outside. The point is not whether there was actually a fire. The point is why the person ran. Notice or knowledge. The statement shows someone had notice of a problem. Example: the manager was told the floor was wet. The issue may be notice, not whether the floor was actually wet. Verbal acts. Sometimes the words themselves have legal significance. Examples: contract offers and acceptances, threats, defamation statements, or notice of cancellation. The fact the words were spoken matters, regardless of truth. Imagine a witness says, "My neighbor told me the defendant admitted stealing the money." Now we may have multiple layers: the neighbor's statement and the defendant's alleged admission. Courts must analyze each layer separately. Sometimes one part may qualify under an exclusion or exception, while another does not. Even when something is hearsay, it may still be admissible under an exception. Why? Because some categories of statements are considered sufficiently reliable or necessary. Common examples include excited utterance, a statement made during or immediately after a startling event. The theory is that spontaneity reduces fabrication. Present sense impression, a statement describing an event while it is happening or immediately thereafter. Statement for medical diagnosis or treatment. People seeking treatment generally have incentive to be accurate. Business records. Regularly kept business records may be admitted if foundational requirements are met. Dying declarations. In limited contexts, statements made under belief of impending death may be admissible. There are many more. The key point is that hearsay law includes both exclusions and exceptions. One of the most important concepts: a statement made by an opposing party may often be used against that party. This is commonly called a party admission. If a party said something relevant, the opposing side may be able to offer it. This often surprises people because it is an out-of-court statement. But the rules treat party statements differently. Sometimes a statement contains another statement. Example: she told me that the accountant said the records were fake. Now there are layers. Each layer must independently satisfy a rule allowing admission. If one layer fails, the whole chain may fail. This is known as hearsay within hearsay, or double hearsay. Outside court, people often use hearsay to mean rumor, gossip, unverified information, or something they dislike. That is not the legal definition. A statement can be rumor and still not be hearsay, depending on how it is offered. And a perfectly serious statement can be hearsay if offered for truth without a valid exception. The legal meaning is narrower and more precise. The hearsay rule helps ensure that decisions are based on evidence that can be tested. It protects against unreliable repetition, distortion through retelling, and absent witnesses whose credibility cannot be examined. At the same time, the many exceptions recognize that some statements are reliable enough, or necessary enough, to be considered. The system balances caution with practicality. Hearsay reflects a broader truth about courtrooms. Evidence is not just about content, it is about method. The legal system cares not only what information says, but how that information arrives in court and whether it can be trusted. That is why procedure matters as much as substance. Hearsay is not a magic objection. It is not shorthand for gossip. It is a structured rule about when secondhand statements may be used to prove truth in court. Sometimes those statements stay out. Sometimes they come in through exceptions. But the purpose remains the same: to ensure that when courts rely on words, those words have earned their place in the record.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.